Good afternoon, everyone, and welcome to Day 3 of the University System of Maryland's second Wills and More Week in recognition of National Estate Planning Awareness Week. My name is Ann Kolakowski. I'm the Director of Gift Planning Services here at the System office. We're delighted that you've committed yourself to learning about this important topic and hope that you have enjoyed the sessions you've seen so far and will join us for the rest of the week. Before we begin today's program, I just want to go over a few housekeeping issues. Again, just a reminder that our session is being recorded, and links to all recordings will be sent with a short survey early next week. We hope that you'll take a few minutes to help us plan for next year by providing your feedback. If you didn't register for the remaining sessions, but you'd like to attend them, the links are found in the email that you got the link for today, and as well as the website itself. So please just join us. We'd be happy to have you. If you have questions as we go along, please put them in the Q&A and keep them general in nature. We'll answer as many as time permits, and you can upvote questions to move them to the top of the list. And lastly, an important reminder that this and all of this week's presentations are being offered for informational purposes only and should not be considered as a substitute for advice from legal, tax, or financial professionals. It's now my pleasure to introduce one of my system colleagues, Kim Robinson, who is the Director of Major Gifts at UMBC. Welcome, Kim.
Thank you. Good afternoon, everyone. I'm delighted to introduce today's speaker, May-Lis Manley. May-Lis is a principal with Landsman Law Group. She graduated from Boston College with a BA and received a JD with honors from the University of Maryland School of Law. Before joining Landsman Law, May-Lis worked for the Senior Law Project with the Prince George's County Office of the Legal Aid Bureau, representing low-income senior citizens in Prince George County. Her practice areas include guardianship and alternatives, Medicaid long-term care eligibility planning and applications, special needs trust, and estate planning. A member of the Special Needs Alliance, the National Academy of Elder Law Attorneys, and the Maryland State Bar Association Elder Law Section Council. May-Lis also serves as the Board of Directors of First Maryland Disability Trust. Welcome, May-Lis. Thank you so much for donating your time to share information about planning for special needs with our audience today.
Thank you. Good afternoon. I'm May-Lis Manley, as Kim just said, and I will be talking about estate planning, especially involving minor children and disabled beneficiaries. And the best advice I can give you is don't wait. If you're doing a will, a revocable trust, you need to have what we call testamentary capacity, meaning you need to be at least 18 years old. Know that you are giving your property away upon your death. Know what your property is. What are your financial accounts? Do you have a house, a condo, a couple properties? Know who your family members are and know who you want to give your property to. And always keep in mind, if that person's not living, have a backup, what we call a contingent beneficiary. I say this because very often I get calls from an adult child, perhaps in their 50s or 60s, who says, my parent is 90 years old and needs to do a will. And one of my questions will be, are there any signs of memory loss or dementia? Yes, she's had dementia for a few years now. And right there, that's it. We cannot go any further. We cannot do that will. So it's something, I always see this as something where everybody has the best of intentions. Don't wait. You can always update wills. You can do a codicil. You could do a new will, but get something down in writing. So who is a minor? In Maryland, a minor child is somebody who is under 18 years old. If you have a disabled child under 18 or over 18, any age, you still want to do this planning. Things to consider for both of these people are nominating in your will a guardian of the person. This is where in your will you say, this is the person I want my child to make medical decisions for my child, be it the minor or a disabled child. They may also be making educational and some social decisions. Could be that most likely they will be living with this person. This is the person I want to be the guardian of the person. And as I said earlier, always name a successor, a backup, because you never know what will happen. And then you want to name or nominate a guardian of the property. This is somebody who will handle your child's inheritance, the money, if it is not going to the child through a trust. Now, remember, when the child turns 18 years old, the guardian would give that inheritance, that money to the child. So we're going to talk in a few minutes about a trust for a minor child and then trust for disabled people. And it may be that you're saying to yourself right now, 18 is pretty young for a child to receive perhaps a couple $100,000. I don't want them getting it at that age. What can I do for the minor child? So this trust for the minor child would be in your will. Your will would say trust for Josie Smith. Child's name is. It's got to be written in your will, not just in your mind, not just telling your family members. It needs to be written there. This inheritance then may go, this trust would be either a support trust or a discretionary trust. It's your choice. For a child with no disabilities. A little later on, we're going to talk about a child with disabilities. So a support trust says that the trustee, the person managing the trust, the person in charge, is to make disbursements, dole out the money for the health, education, maintenance, and support of the minor child. And those are defined terms. They're somewhat vague, but they're defined. A discretionary trust, on the other hand, says that the trustee has complete discretion to make disbursements for something along the lines of the care, comfort, and advancement of the child. This is not as defined or not as strict a standard. So you can consider both of those and think about who is your trustee, who's going to be the person in charge doing this. Do you want a more defined standard? So this trust also would state at what age the child receives the money or the inheritance. This is your decision. Like I said earlier, if there's no trust, it goes to the child at age 18. If you're thinking, no way, I want my child to have the money, they'll blow through it, then what age do you think is right? There's no right, there's no wrong. You know your child. Somebody might say 25, another person might say 30, somebody else might say 35, 38. It's up to you. We also say in this trust, how if there is any income that the trust earns, and it should be earning income, do you want the income to be distributed to the child at a specific age? Or maybe not. But if you say, yes, I want them to learn to manage some money, so I want them to receive the income only, maybe starting at age 21 or 22, 23. And how often do you want them to receive this income? They could receive it monthly, which is more difficult. It's more work for the trustee. Or you could say, I want them to receive it quarterly or perhaps annually. That's up to you. And then we look at the principal. The principal is the bulk of money that is in the trust, assuming it's all money. And again, at what age do you want the child to receive this? And do you want the child to receive it in a lump sum all at once at age 25? Or do you want to say, I want it staggered. I want the child to receive 1/3 at age 25, so they have something, and then another third at age 30, so that now they're a little older, perhaps a little more responsible, and then the rest at age 35. You get to pick those numbers. I just used that as an example. And if you want the trustee to be able to use the trust funds while it's in trust, which most people do, you need to state that in the trust so that the money isn't just sitting there waiting. It might be that the guardian for the minor child needs the money to help pay for the child's education or some living expenses. So state that clearly. The trust money can be used for the beneficiary. So the trust also should, I am going one more slide. Okay. So if you have more than one minor child, you may want to consider a pot trust. And what a pot trust is all the money goes into this pot trust to be used for the children. Say you have 2 children. One is age 17 and one is 10. And you figure over the lifetime of the 17-year-old, you've spent more of your own money on the 17-year-old than the 10-year-old, simply because they're older, and probably more larger chunks of money as braces, maybe PSAT or SAT course, maybe some tutoring. So if you put the money in a pot trust, you can say, I'm letting the trustee decide how to use this money for both children. It can be unequal because now it might be the 10-year-old's turn to get braces, which are going to be a larger expense, or maybe needs some tutoring for school that the older child is past those. And then you say in the trust, in your trust, that at a certain age, when my oldest child reaches maybe 25 years old, the pot freezes. And at that point, it breaks up or separates. One for the older child and one for the younger child. And at that point, they are each receiving 1/2 or 50% of what was in the pot trust. But it's just the pot trust is a way of equalizing the funds for the children. So now we're going to talk about who are some of the players, and the most important is the trustee. And the trustee is somebody who needs to be responsible and trustworthy because they're going to be managing these funds in the trust. They'll decide who to invest them with. You want, of course, want somebody who is not going to choose risky investments. They're also going to be dispersing or distributing the funds on the child's behalf, if that's what the trust says. Always, always remember, this is not a popularity contest. Any concerns that I really should appoint my sister, because if I don't name her, she's going to be really hurt and upset. That is not a good criteria for picking a trustee. You want somebody responsible and trustworthy, and you should ask them, are they willing to assume this role? Some people say yes. Some people say, I think that would be a lot, and I just don't think I can do it. And honesty, because you don't want somebody in the role who is taking on more than they can chew. You also want to consider, do you want the trustee to have to, we say, post bond? And think of bond as insurance, like you have vehicle insurance or homeowners insurance. Same with the trust. A bond is like trust insurance, so that if the trustee runs off with the money, the bond company will put the money back into the trust, and then they will go after the trustee. And like I said, with the guardians, name one or more successor trustees. You just never know what might happen to your original named trustee. And ask those people if they'd be willing to serve as successors also. So now we're going to talk about what if the person, the beneficiary of the trust or of your will, is disabled. You have a disabled family member, and for the sake of ease of presentation, I'm going to say, let's say this is a disabled adult child, maybe 30 years old, intellectual disability or on autism spectrum, whatever, any of those disabilities fit this criteria. So what you want to consider is, do you need to put this beneficiary's inheritance into a special needs trust? We would call it a third-party special needs trust. I'll talk about that in a minute. Or a discretionary trust. Or if you don't have anybody to serve as trustee, maybe you would consider a pooled special needs trust. And we'll talk about that in a minute too. You might also consider an ABLE account. But know with an ABLE account, there are a couple criteria. The disability must have occurred before age 26 as of January 1st, 2026, next year. That age for disability will increase to 46. So more people will be eligible for an ABLE account. And all combined annual contributions to an ABLE account cannot exceed $19,000 in 2025. And for next year, the number remains the same. That came out after I prepared these slides. So an ABLE account might be a good consideration if somebody is going to be receiving a $5,000 life insurance policy, but it certainly would not be a consideration if they're going to be receiving $100,000. Two other things about an ABLE account is that it currently, on the law, the ABLE account has what we call a Medicaid payback. And that means that when the beneficiary, the disabled person who has the ABLE account, dies, if there are funds remaining, then those funds go first to repay Medicaid for what Medicaid has paid for that individual. That is why you want to be judicious in deciding, is an ABLE account best? If you're leaving just a small sum of money, for example, $5,000, a life insurance policy, and the individual with a disability is young and you know they're going to use up that money, then by all means, an ABLE account would be most appropriate. Know that right now, Maryland is not enforcing the payback on ABLE accounts. Could that change? It certainly could. So this trust for the disabled person could be a child, it could be an adult. Really, it could be a parent who has dementia and you want to make sure that there are funds set aside for that parent. It's really for somebody who cannot manage their own money. Perhaps they receive means-tested public benefits, which are things like Supplemental Security Income, SSI, or Medicaid, or there are other state programs that are means-tested like that. And means-tested means in order to receive them, one of the criteria is that the person receiving or about to receive does not have more than a certain amount of assets in their own name. And very often this is $2,000 or $2,500. It is a very low limit. It also the disabled person could be somebody who is not yet receiving means-tested public benefits, but they very likely will in the future. And it may be somebody, I'm going to go up to the top one, somebody who cannot manage their money. It might be that they're not receiving any public benefits, and perhaps will not. Very often I see this with an adult child, perhaps in their 20s, 30s, 40s, who has mental illness, but may not acknowledge their own mental illness, or they may acknowledge it, but when they have a psychotic event, it is very likely that this person will give away all their money, and therefore using a trust would be ideal for this person, so that somebody else is managing their money and the money will be there for their as long as possible. I have down at the bottom of the slide asterisks saying, if the disabled person receives or might receive means tested public benefits, this trust must be what we call a sole benefit trust. Must be for the sole benefit of the disabled person. Must be a discretionary trust, not having the HEM standard, not having the standard that the trust disbursements be for the health, education, maintenance, and support. Instead, you want to say that this trust is for the comfort, care, and convenience of the beneficiary. And you do not want to include mandatory distributions of income or principal, because that could kick the individual off any public benefits programs that they are receiving. So, what is a special needs trust? This is also known as a supplemental needs trust. Same thing, I don't know why they have different names. But the title does not matter so much. You could call it the Jamie Brown Trust. You could call it the Jamie Brown Special Needs Trust. Maybe the Jamie Brown Supplemental Needs Trust. The title is not important. It's the terms of the trust that matter in the body of the document. And that's where you need the trust to say the beneficiary has no control over the trust funds. The trustee has sole and absolute discretion how to invest the trust funds, how to make disbursements of the trust funds for the sole benefit of the beneficiary. As I said earlier, this is not a support trust. It is a discretionary trust. The trustee has the discretion to decide what to purchase, what items there are that the trust beneficiary may need. Now, I'm going to pause for just a second to say that if you look and you see that there is an older special needs trust that perhaps a grandparent or somebody created years ago, and it says something to the effect of the trustee has sole and absolute discretion over the trust funds, with the trust funds to be used for the health, education, maintenance, and support, so that you've got what we call a discretionary support trust. Maryland law says that is acceptable. There was a court case years ago, and that is acceptable. However, when I draft new trusts, I never would include that, because we just don't know what the future might bring. So out of abundance of caution, you want it to be just a discretionary trust with no HEM standard in there. So other notable items about a special needs trust. If the trustee is receiving any of SSI, Medicaid, any of these means tested public benefits, the trustee does not want to give money to the trust beneficiary or into the beneficiary's bank account and then take that money to buy things for the beneficiary. If you do that, then SSI or Medicaid would say, thank you very much for putting that money in the bank account. We're going to kick you off our program because now you have more income or more assets than you should, or pay some of it to us. Instead, what the trustee should do is pay the vendors or the providers directly. If there's somebody providing physical therapy or any type of therapy, emotional therapy, pay the therapist directly from the trust. If the beneficiary needs a new iPad, for example, Trustee can go on Amazon, go on Best Buy, go to a store, wherever, buy the iPad directly, give it to the trust beneficiary. The advantage of doing a special needs trust in your estate planning is this special needs trust has no Medicaid payback. So the difference is you get to say, if there's the money does not go to Medicaid. You don't do this planning, the child inherits what we call intestate. Money is considered a special needs trust, a first party special needs trust, and that must have the Medicaid payback. So that's a huge advantage of doing this trust, doing this planning and setting up this trust now. So who should be the trustee for this special needs trust or a discretionary trust for a disabled person? Same as before, trustworthy, responsible. And I add, I think it's been very beneficial to have knowledge of SSI and Medicaid rules, because if the distributions are made incorrectly, like I previously said, that could terminate, suspend any benefits, and often it could take a while to get the disabled person back onto receiving these benefits. Some people tell me, I just don't, clients say, I don't have a family member who can be the trustee. I really don't know, who do I pick? What do I do then? Then I say you may want to consider a pooled special needs trust. There are two in the Maryland area, First Maryland Disability Trust. I'm on their board of directors. I do not get any remuneration for referring clients or for serving on the board. Another one is the Wesley Venner Memorial Trust through Shared Horizons. And then there are several national pooled special needs trust companies. And they are all nonprofits, but they do have to charge a fee to keep themselves going. But they understand the SSI and the Medicaid rules. And I think it is hugely important. So that's something to consider if you're thinking, who do I pick as a trustee? So what makes a will valid? Well, it has to be written, signed by the testator, has to be witnessed by two credible witnesses, not somebody, which means two people over 18 have mental capacity and not somebody who is going to inherit. After the will is signed and witnessed, do not make handwritten changes. We see this a lot, and the handwritten changes are problematic. Let's just say, don't do it. I also see have a lot of clients who come in with a will that is not signed. It's not a will. So make sure it is signed. In your will, you will want to name a personal representative. Maryland, we call it personal representative. Other states call it an executor. And just know that this person carries out the directions in your will. They do not have the right to change and decide what they think would be best. Where to store your will? I think the best place is with the Register of Wills for the county in which you reside. They charge $5. You can get it back at any time. If you do a new will, you could file the new will there also. I think it's even if you move out of state, they can send the will to the Register of Wills for the new state or different county you're residing in. I think it's $5. That is very well spent. I want to take a minute and say, after you do your will and you're thinking, great, I've got this taken care of. Not quite done yet. You want to make sure that you look at the beneficiary designations for your retirement plans, life insurance, anything else that may name a beneficiary designation, and see who you are leaving this to. Perhaps it says primary beneficiary is my spouse. My contingent or second secondary beneficiaries. Say you have 3 children, one of whom is disabled. So and let's say one of those 3 is also a minor. So you might say, I want the 1/3 to child 1. I want 1/3 to the Jamie Brown Special Needs Trust, and under agreement dated, meaning the date that you wrote it, but you definitely need to name the special needs trust and not just put your child's name. And then for the 3rd, the minor child, you would write, I wanted to go to my daughter, Mary Jones, provided that she is whatever age you pick, say 25 years old, provided that she is 25 years old. Otherwise, to the Mary Jones Trust, established in my last will and testament, dated October 25th of 2025. Those beneficiary designations are important, and you want to check them every few years, or if there's a major life event, because you may all of a sudden say, oh, that minor child is 25 now, the one, I think she can handle money. Let's just leave it to her directly. It just eases all. Power of attorney is another document. I don't know if anybody was speaking about these, but I just want to give a quick plug to powers of attorney because I think these are incredibly important documents. It's who would manage your funds when you're living and perhaps you have memory loss, you have dementia, you're in that terrible car accident, and you can no longer access or handle your funds, write checks, pay bills. This would be the person you name in your power of attorney who would be able to take over and do this for you. If not, you end up having to go to the court for a guardianship, and you want to avoid that if possible. And so another item I will mention, we talked earlier about putting in your will or your estate planning documents, who would be the guardian for your minor children or an adult disabled child, because they lack the mental capacity, that ability to make decisions for themselves. Very often I'll have a parent come in and say, I have a child who has a disability. They are 17 years old. Both the school and doctor have told me that once they turn 18, I need to have guardianship of the person so that I can make healthcare and medical decisions for them. Can you help me? And I always say, I sure can. And we pause, talk about, do you really need guardianship of the person? Because Maryland has what we call Maryland surrogate decision-making laws that state if a person lacks the mental capacity to make responsible healthcare decisions and it's certified by 2 doctors, then these are the people who can make those decisions for them. First would be a guardian if there is one. Let's say there's not. Is there somebody under a power of attorney or advance directive? No, because this adult disabled child never had the mental capacity to understand and sign an advance directive or healthcare power of attorney. So we keep going down this list, and next would be, there would be a spouse, any adult children, then parents. And that's where the parent can come in and make these healthcare decisions for the adult disabled child without having to get guardianship. Because if you have guardianship, the court is the ultimate guardian, and the parent is giving up a lot of power that they already have to the court. They will have to file annual reports with the court, but more so if there is elective surgery that the parent feels would benefit the adult disabled child. The parent would have to ask the court for permission for that surgery. If the parent wants to retire and move out of state, somewhere down south, it's a little warmer, and wants the adult disabled child to come with them, the parent would need to get the court's permission. And I just think the parent has all this permission, has this power anyway, without getting guardianship. Avoid if possible. Schools and doctors, healthcare providers are not aware of the Maryland surrogate decision-making laws as much as they should be. So it might involve education on your part. A lot of times I send my clients an email that says, this is what you should provide to the doctors, healthcare providers, let them look at it. If there are questions, I'm here to educate them, talk with them, and it's always worked. It's always worked. It's just that they're not aware of this less restrictive alternative to guardianship. And that is the end of my presentation. Thank you.
Great. Thank you, May-Lis. We really appreciate it. I think we have some questions in the Q&A. The first question, what is the price to create a trust? And what is the monthly maintenance fee? And then who is doing tax returns for the trust?
So let's start with the last one. The trustee would want to make sure that tax returns are filed for the trust. And that is important. That's a great question. What are the fees for setting it up? It varies attorney to attorney. And it varies on, are you doing a standalone special needs trust where it's its own document because perhaps other people will be leaving funds to the special needs trust, or are you putting this trust inside your will or revocable living trust, which is usually a little less expensive. But I would say, it varies. It could range from, I don't know, maybe 2,000 to 6,000, depending on who is doing it, how involved it is. That's also why sometimes people use a pooled special needs trust, because those are less expensive and you can do it with or without an attorney. And it's another alternative.
Great, thank you. April asked a question, do you practice in Baltimore City? And if no, would you be so kind as to direct any staff member of University of Maryland, Baltimore who lives in the city to a few agencies?
Sure. I would say if you send me an email asking for contacts in Baltimore City, I would let you know some.
Great, thank you. And then the final question that we have is, what kind of trust is appropriate for an adult child who is on SSDI as opposed to means tested SSI?
So that is a little easier. I would just use a discretionary trust again, saying I tend to like that standard of disbursements being for the care, comfort, and advancement of the child. You don't have to worry about that $2,000 limit, which is terrific. And you just want to make sure at the same time that that adult disabled child does not receive any Medicaid benefits that might have a limit. But otherwise, and we often do this for individuals who are receiving SSDI. A lot of the terms are the same, but I would just use a discretionary trust. You could call it a special needs trust. You might not. You could just call it, child's name trust. But again, a lot of the terms are the same. It could be in this case, though, that the trustee can give money to the individual's bank account rather than the trustee having to pay vendors or providers directly.
Great. Do we have any additional questions that people want to put in the Q&A?
It looks like someone just added a question.
Okay. Hold on just a second. Sorry about it. Okay, here we go. Let's see. Does a will have to be notarized if the two witnesses pass away before the will is implemented? Are there issues?
A will does not need to be notarized in Maryland. It just needs the two witnesses. And there is no issue if the witnesses pass away before the testate or the person writing the will.
Right. And then it looks like one final question, if something didn't pop up, is there a mechanism to pay a trustee for their efforts from the trust's assets?
Yes, and you can state that in the trust, how compensation should be paid to the trustee. And I think it's important to realize the trustee is doing work. So you do want them to be content. So you do want to pay them. I think you are asking for trouble if you are not not compensating the trustee. And I will say one last item along those lines is I am not a fan of big banks being the trustee of a special needs trust. I think their goal or their perspective is, let's see this money grow while it's in the trust. And, kind of like thinking more of generational wealth and can be passed on to other family members. And that's not the idea behind a special needs trust. Of course, you want the money to grow and to be invested, but with a special needs trust, it's also the trustee needs to understand that there's somebody who needs this money, because if they're getting SSI or SSDI, it's not that much money. They really need these funds in the special needs trust. So you want a trustee who understands that. I believe the Pooled Special Needs Trusts understand that. I have not always seen big banks understand that. Some do, but not all.
Great. Couple more questions. You mentioned handwritten notes on wills are problematic. Is the same true for trusts, or no, because a trust is private?
It's the same. You do not want handwritten notes. Instead, go ahead and amend your trust. Do a new document, or you could just do an amendment, which is an add-on. Sometimes if there are going to be a lot of changes in the amendment, I recommend what we call an amendment and restatement, where we just do a new document that says this trust was first created in 2019. We are now amending and restating it so that we have one document in one place, rather than having a trust and 5 different amendments, and you're trying to cut and paste and figure out what the terms are, and things get confused that way.
Okay. And then another question that came in, can children be beneficiaries on an irrevocable trust, even if there is a spouse?
Sure. I don't know if anybody else was speaking about disinheriting spouses. Maryland does not let you disinherit a spouse. So as of a few years ago, Maryland it has never let you disinherit a spouse, but the rules changed a couple of years ago. And now what happens is we look at everything you owned at the time of your death, whether it passed through a will, whether it passes through a trust, life insurance, retirement plans, and your spouse can file an election against your estate and get 1/3 of all of that.
Great. Anne, I think we've covered them all. Unless there's one more.
I think they're still coming in. So
they're still coming in. Okay.
Yeah. Just great. Bring them on.
This is great.
We have May-Lis with us and get this expertise. Yeah.
Perfect. How do you ensure that the trustee is executing the trust correctly?
That is a wonderful question. You don't know, because most of the time you're dead. So you are putting a lot of trust and faith in that person who is going to be the trustee. Perhaps in your special needs trust, you want to add a trust protector or a trust ombudsman. Same thing, just different names. And this person does not have what we call a fiduciary duty. We often say that the trust ombudsman or trust protector can get as involved as they want or be as uninvolved as they want, but they somewhat act as a liaison between the beneficiary and the trustee, so that, and they can receive, if you put it in your trust document, you may want to say that the trustee must provide annual statements or annual accountings to the trust protector ombudsman. So there's another set of eyes and ears seeing what's going on. And then the trust ombudsman might say to the trustee, hey, Mark really needs these things. He needs a new bed, a new mattress. What he has is old and the mattress is just lumpy and falling apart, and he's got back problems now. Come on, you need to get a mattress. And somebody who can kind of compel, the trustee just says, no, I'm just going to keep the trust funds in here. I want to see them increase. Then if you have some concerns that might happen, you might want to give in the trust document the ombudsman the authority to be able to remove a trustee who is not doing an adequate job. I like to put limits on that. Perhaps cannot remove a trustee more than every 3 years or something like that, and that the ombudsman cannot be a successor trustee, because you don't want to set it up to somebody's advantage. But I think that is one of the most important decisions, who is going to be trustee.
And then one other question, similar to a trust, if you need to make a change to a will, should you do an amendment or a new will? And then and to piggyback on that, someone actually asked another question that goes hand in hand with it. They wanted to know, should the amendment be done by a lawyer? So it gets us 2 questions with one.
So I'm going to say yes. I think it should be done by a lawyer, because you want to make sure it's done correctly. Otherwise, it's just not worth it. It doesn't exist. And you would not do an amendment for a will. You could do what we call a codicil, which just says, I'm adding on to the will that I executed on July 16th, 2019. Here's my codicil. I'm changing Article 5. I no longer want person 1 to be the personal representative. I want to change it to this person. And you could do a codicil like that. Again, the codicil has to be signed. It needs to be witnessed by 2 people. It might be that if you have a lot of changes, or you're going back to the attorney who did that first original will, if it's all on our computer, it's so much easier just to do another will. The cost is basically it should be about the same, because you're thinking codicils were used more in the day of typewriters, when you didn't want to have to go back and retype everything. But today, if you've got it on your laptop, it's on your computer, you can just change things so easily.
And do we have time for one more question, or are we at time?
No, we're good. We have 10 more minutes actually. So
great, perfect.
Yep.
So if you create a trust for a home with your children beneficiaries, after your death, they sell the house, will they pay taxes on their gains?
I am not a tax person or a tax expert, so I'm going to leave that to them.
Great, perfect, thank you. Any other questions? We have a couple more minutes, so if not, I'll turn it back over to Anne.
Great. Well, it looks like we've been through all the questions. May-Lis, I learned so much today. It really reinforces in my mind that especially if you have children, or if you have anyone in your life who really does have any kind of special circumstances, that it's super important to get this handled. Oh, I see one popped in the top. Is it more beneficial to inherit a house from a will, or add children to a house deed, such as a quitclaim deed?
I think it's more inherent. So I'm going to, despite what I just said about not being a tax person, I can't answer this question. tax-wise, it's more beneficial for the children to inherit the house because they receive a step up in basis as opposed to just doing a quick claim deed. There is something else out there that we use a lot when we're doing Medicaid planning, which is called a life estate deed. And if we're doing Medicaid, we do a life estate without powers. And that means that if you do that deed, when the person owning the house, let's say it's the parent, they own the house as long as they're alive. They don't have to be living in the house. And then when they die, the house passes to the children, and the children receive that step up in basis, which is more tax advantage for the children. That's a very simplistic view of a life estate. So that I think you would want to consult with an attorney, decide which type of life estate do you want? What's your purpose in doing it? If Medicaid's in the future, then you might want the life estate without powers, but know that if you do want to sell the house, you have to have the children agree to selling the house and sign off on it.
Definitely, that was the situation in my own family with my mother. We had that in place. So there's no perfect answer because that created some issues, but it also protected the asset for us. Let's see. Questions. Does Maryland have a transfer of deed on death to avoid a trust if a trust is not otherwise necessary?
It does not. It's been introduced as legislation and it has never passed. Not yet.
So call your representatives if that's important to you. So get that back up there. Mm-hmm. Great. Okay, and then the final question is actually one I can answer, and that was, will the recordings and the Q&A be available in the future? And yes, we will be sending links to all the recordings from this week, early next week with a survey. So you'll be able to go back and watch and absorb and catch all things that you might have missed because there's been a lot. One little definition, just in case you're curious and you're not familiar with what a step up in basis is, it's basically the difference between what was paid for something and what it's worth now, and that can be subject to capital gains. And when you inherit something like a stock account from a parent, say the stock was purchased at $10 a share and now it's worth 100, you now get the benefit of it being worth 100, so you don't owe taxes on that. So and I'm not a CPA either, so again, this little term of art, there are an awful lot of them in this business. So anyway, May-Lis, thank you so much. This really was very helpful, and we appreciate your time and the service that you're providing to us today, as well as what you do in your professional volunteering. It's really important work, so thank you so much. And to everyone else, this will conclude today's webinar. Please join us tomorrow. We're going to have Sherry Fleming, who is an attorney who also happens to be the director of plan giving for Bowie State, and a wonderful, delightful colleague and presenter who's going to be talking about building intergenerational wealth and how to pass your values on to future generations, which I know is going to be a great topic. And I wish you all well. Enjoy the rest of your day. Thank you so much for joining us.
Thank you. Bye now.